All right. Well, looks like we've got folks situated. Thank you again, everybody, for joining. I know this was short notice, but there are a lot of moving parts. So thank you for taking time out of your morning just to introduce the chamber and PSBP Law. My name is Gamal Fulani. I'm the executive director of the U.S. India Chamber of Commerce, DFW. We are your U.S. India Chamber here in the North Texas region. We want to provide this webinar because we know the intricacies and the nuances and so many questions that our members and our larger member companies have with the complexities that are changing here with this new proclamation that was signed by the Trump administration over the weekend. We have partnered with PSBP Law to bring you this webinar this morning. Most of our members and a lot of our community folks know PSBP Law as the Patel Law Group. They have recently rebranded to the Patel Sony Varsness Prescott Law Firm, PSBP Law. They are a very trusted firm for the chamber. We've worked with this law firm for a long time. We have enjoyed the partnership with PSBP Law, and they've provided great services for our members and the greater North Texas community. And just to lay kind of the framework before I introduce Chris, we are hosting this, as I mentioned, because we want to ensure that with this order that came down impacting H-1B visas, we can provide some clarity. Chris can provide clarity, answer any questions you may have, and also from a member company standpoint, if you're participating on behalf of your organization, we want to ensure that you also have the tools and resources to take back to your colleagues and provide that information. So without further ado, I'm going to introduce our expert here this morning. Representing PSBP Law is Chris Prescott. Chris is a partner based here in their Irving office, and he leads their immigration team. Chris represents individuals and corporate clients in the DFW Metroplex and throughout the U.S. in all aspects of immigration law, and he prides himself in providing very fast and effective legal advice to help individuals and businesses navigate the ever-changing landscape that is the immigration front. So with that, what I will do is I will just kind of, Chris, if you don't mind, we'll just have a conversation here. And then what I will ask, just a few housekeeping items, if folks can mute themselves. We will have time for Q&A because I'm pretty sure people have a lot of questions, and we'll have time towards the end of this webinar. So with that, Chris, can you just kind of talk us through some of the provisions, who's being impacted,
Sure.
And we'll just kind of go from there.
Absolutely. Well, thank you for everyone that's attending. Obviously, thank you to the Chamber for organizing this event. One of the things that you said that you were hoping for was clarity. I'm certainly going to do my best to provide that clarity, but in 15 years of doing immigration, this is probably the first policy update that has caused more confusion than anything else. A lot of things that I will say today, I think, are going to be my personal view, my personal interpretation of the proclamation, of the memos, and I'll kind of go through what the timeline was in terms of the proclamation that came out on Friday and then the memos that subsequently followed. But those memos are only, 2 paragraphs. The proclamation is a very short proclamation, and it's really just an idea. This has not been implemented by the various agencies involved in this, and it's $100,000 fee. That's what we're talking about. So there is a lot to unpack. Kamal, if there's something that I miss or you want to kind of interrupt and you want me to expand on, please feel free to do so. So from the timeline perspective, so the proclamation was signed on Friday, basically ruining everybody's weekend. I was actually out of the office on Friday, so I didn't even get to look at this until probably late on Sunday. The proclamation said that it would restrict the entry of H-1B workers into the US unless it was accompanied by a $100,000 fee. The one thing I want people to know is there was somebody in the government that suggested that the fee should be $500,000. And then somebody else said, I think 500,000 is too much. It should be 100. And that's where this fee came from. So there's no rhyme or reason to the actual amounts. I think it's more for shock value. When it first came out, a lot of people that were outside of the US believed that it applied to them. And there was a rush for people to try and come back to the US by the cutoff date, which is September 21st. On Saturday, CBP and USCIS then released memos, essentially backtracking, saying, well, actually, it doesn't apply to people that have got petitions that were filed prior to September 21st. It doesn't apply to people that have approved petitions, and it doesn't apply to people with valid H-1B visas. And then on Sunday, USCIS released a frequently asked questions, and then the Department of State provided some guidance. So we're in a situation where we have a proclamation, we have multiple memos, we have some guidance, but we still don't have the flesh on the bones. So there are certain scenarios where I'm still not 100% certain whether this fee applies. I thought after yesterday, I was pretty sure on, the circumstances in which it would apply. And then I read something this morning, which there are other attorneys saying, well, actually, it may not apply in those circumstances.
And so on that, Chris,
yep.
Just quickly to kind of just hop in, I just to kind of reiterate, because this question has kind of popped up through our chats with our members. I'm sure folks on the call today through WhatsApp, through text messages, this has kind of popped up as well. But does this already apply to petitions that are in progress?
So no, it doesn't. So I was going to go through the scenarios where I think it applies and where I don't think it applies. So the memo from CBP and USCIS says it's only for petitions that have not been filed. So somebody that filed a petition prior to 9/21, somebody that has an approved petition or a visa, it doesn't apply to those people. So anything that's pending, USCIS can't come back and say, well, actually, you now have to pay an additional fee of $100,000.
So people are grandfathered in then, is kind of what your interpretation is.
Correct. Yeah.
And do you know how the fee is going to be collected? Has the administration put out more information on that?
So they haven't. So it's not even clear who the fee will be paid to. So there's three agencies involved in this. You've got USCIS, you've got CBP, and you've got the consulates, which fall under the Department of State. So there could be a situation where somebody files a petition with USCIS where the fee is not payable, but then they subsequently leave and have to go for a H-1B visa stamping. And at that point, the fee could be payable. So it's not clear whether it's a filing fee, whether it's a visa issuance fee, or whether it's an entry fee. So, and it's also not clear who can pay the fee. Typically H-1B fees have to be paid by the employer. If this was a filing fee, it would have to be paid by the employer. But if it was a visa issuance fee or an entry fee, it could potentially be paid by the beneficiary, in other words, the employee.
Got it. And and I know you said you're going to kind of walk through just the instances and some of the circumstances. Before you get to that, I just wanted to ask you one additional question. From y'all's working with the other immigration agencies, has the administration put out any more clarity as to when they think that they might have a more concrete idea of working with CBP, USCIS? And having something where it's okay, it's an order, this is firm. Any timeline on that you can share?
Unfortunately, there's no timeline. Again, there's no payment mechanism. So even if we determine that somebody is subject to that fee, they haven't said how that fee will be paid. And they haven't given us a timeline. This could also be challenged, and it will be challenged in federal court, which means that what we're discussing today, in 2 weeks' time, it may not even be relevant. But again, I don't believe a lawsuit has been filed yet. I think it's probably going to be filed this week. and that could certainly, prevent the implementation of this new fee.
Got it. Thanks, Chris. And I'll let you get back to, I know you were going to dive a little bit more into those scenarios.
Yep.
So, yeah.
Okay. So the proclamation specifically references people outside of the US. The way that it's worded makes it sound like a travel ban. So again, this is my personal opinion. I think anyone that's in the US that's filing a H-1B extension, a H-1B transfer, a H-1B amendment, or even a change of status, let's say from H-4 back to H-1B, should not be subject to the fee. But then I read this morning, and this was another very large law firm that made the point that in the USCIS frequently asked questions, they say that this fee won't apply to H-1B renewals, which means that if somebody is applying for an extension with the same employer, the fee doesn't apply. But if they're switching employers, it could apply. I don't think that will necessarily be the case. I think anyone that's in the US that's applying will not be subject to the fee. But that doesn't mean that if they subsequently leave the US and need to go for visa stamping, that fee won't apply at the consulate or when they try and enter. So anyone that has a pending or approved petition that was filed before 9/21, because that's the cutoff date, should not be subject to the fee. Anyone that has a valid visa, so if somebody is outside of the US, as long as they have an approved H-1B and or a valid visa, they should not be subject to the fee. So again, if somebody's outside of the US and they have a H-1B approved that was filed before 9/21, even if they have to go for visa stamping, that fee should not apply. So in terms of, and did you have any questions on that? But the next category, I think, is who I think it does apply to.
I was going to, just to say, applying and whatnot, you might get into this a little later, but do you have any guidance on what some of our member companies should do and be on the lookout for as their employees are traveling back and forth through their H-1B visa?
Yeah, I think the issue with travel and the issue with travel under this administration, 95% of immigration attorneys have told people, if they're not a US citizen, you shouldn't travel. When I heard this advice early on, I thought, it's a little bit extreme, but then we started hearing all these horror stories of even green card holders, getting detained and deported. I think anyone that's on a H-1B that's currently in the US should not travel unless absolutely necessary. If somebody does need to travel and they have an approved H-1B and a visa, they can potentially travel, but you've also got to bear in mind that the president could sign another proclamation, they could sign another executive order. So whilst that person is eligible to travel now and perhaps is not subject to this new fee, it doesn't mean that in 2 weeks' time when they come back, there won't be another provision. So the advice is not to travel unless absolutely necessary.
Got it. So everything, and just to kind of clarify and reiterate, and what we're hearing from you, Chris, and PSBP law is that things are just very fluid. There's still not a lot of clarity, even for large employers and even individuals. And we're still really getting this information, day to day. And things could change from what you're saying, Chris, in the next few weeks or the next day with what the administration does.
Absolutely. And I think if immigration attorneys, and there's immigration attorneys that are far more experienced than myself, they're still struggling to come to terms with the scenarios in which this fee would apply. So until the immigration attorneys can figure it out, I just don't think there is that clarity. But again, there may be a memo that comes out tomorrow or later this week or next week that provides some of that needed clarity. But the one thing that I need people to understand is just because USCIS puts out a memo, it doesn't mean that that memo is going to be followed by the consulates and the Department of State or by CBP. these are different agencies operating under different rules. So because, we've seen cases where, for example, USCIS approves a case within a day or two, but then the person goes to the consulate and the consulate starts asking for different documentation. People try and come back and CBP start asking different questions. So they kind of almost operate under different sets of rules. I mean, there's some kind of commonality, but don't just think that you've read a memo from USCIS and believe that that applies when you travel, because the rules on traveling are going to come under the Department of State or CBP.
Great. And before we, you pivot to your next topic, Chris, is there any recommendations you give our member companies and organizations to do here in the, I don't know, maybe in the next 30 days, just to better prepare for this? Do you have any guidance on anything of that sort that they can communicate to their employees or from a leadership standpoint, implement?
Yeah, I mean, I think people need to stop. The problem is we live in a society now where everyone just posts online. I didn't post anything over the weekend, and I think there's a lot of people that are posting, attorneys, non-immigration attorneys. I think people need to get their information from a reliable source, whether it's me, whether it's kind of well-known attorneys. Obviously staying up to date, because again, this is a fluid situation and, things could change drastically. But also understanding that what I say today, they may listen to a different webinar tomorrow where another attorney says something entirely different. Because again, this is kind of like our personal interpretations. I don't think there's necessarily anything employers can do other than staying up to date and really just, informing their employees, don't travel unless you absolutely need to. And if you do travel, be prepared for delays. It's going to take some time for these agencies to implement this new fee, which means that when people go to the consulate, when people come back into the country through CBP, those agencies are still trying to figure things out, which means that if you're coming back, there's going to be significant delays.
Great. Thank you, Chris. And I'll let you jump onto the next, your next topic.
Sure. Thank you. So anyone that is filing a new petition going forward, particularly if they're outside of the US, will be subject to this $100,000 fee. So I'll give you an example. I have a client that has maxed out 6 years on H-1B. They're outside the US. The employer is filing an I-140. Once that I-140 is approved, they can then extend the H-1B beyond the 6 years. The problem is that person's outside the US. The employer then has to file a new H-1B petition, which is filed after September 21st. That person will now be subject to that $100,000 fee. CAP exempt employers, so universities, non-profit organizations associated with universities, non-profit and government research organizations, they don't have to go through the H-1B lottery, which is what most employers have to do, which means that if a university files an application, let's say next week, they could be subject to that fee. And it's not clear, whether that beneficiary has to be outside of the US. So even if the beneficiary is here, those types of employers could become subject to the new fee. The new USCIS frequently asked question says that this fee will apply to the 2026 H-1B lottery. So the next lottery is in March. Again, we don't have clarification. Does this fee only apply to people outside of the US, or will it apply to anyone that's applying through the lottery? But based on what they're saying, they're not really making that distinction. So the gray area for me is, let's say somebody is in the US and their employer files a H-1B extension. Based on what USCIS is saying, they won't have to pay that $100,000 fee because it's a H-1B renewal. But if that person now leaves the US and goes for stamping, based on the guidance from the Department of State, because that petition was filed after 9/21, and that person is seeking a visa or seeking to enter the US, I think that person could then be subject to the fee either at the consulate or through CBP. And again, I don't know where the fee is going to be paid. So people that are not subject to the fee that are in the US could become subject to the fee by virtue of travel. So again, that's why most attorneys are telling people not to travel at this point.
Got it. Thanks, Chris. And I just wanted to remind our attendees today, again, thank you for hopping on. We know you have a lot of questions. We will give some time towards the end. I want to let kind of Chris finish up, just touching on some of the additional topics that he has. And we will ensure that we have a good bit of time, because Chris, you and I probably know that the questions are probably going to be the ones where some of our attendees kind of have just an uncertainty. So again, folks, hang tight. We'll get to all the questions as we can. I'll let Chris finish up here in a little bit. Again, Chris, for our late attendees that came in a little bit later, Chris is Chris Prescott. He's with PSBP Law. And he's their lead immigration attorney. So, Chris, I'll just let you jump back into some of the additional topics that you want to touch on.
Okay, thank you. So one of the things in the proclamation was they refer to a national interest exception. In other words, if somebody is working in an industry that's deemed to be in the national interest, they could potentially be exempt from this fee. I don't think that this will apply to, for example, big tech companies. I think it has to apply to an entire industry. I don't think they can say, well, Microsoft is exempt from this, but smaller or medium-sized IT firms are subject to the fee. So they haven't said how that exemption will apply. It's more likely to apply to kind of the medical field or healthcare, kind of doctors and hospitals. But again, we don't have clarity on that. So that's the kind of clarity that we're hoping for, in the next few days. And then the other thing is, as I kind of mentioned, the expectation is there will be a federal lawsuit filed. So there is an organization called Impact Litigation. There's two kind of prominent immigration attorneys, Charles Cook and Greg Siskind. So they were ready to file a lawsuit on Sunday, because when the proclamation first came out, they thought that anyone outside of the US was potentially going to have to pay this $100,000 fee. Apparently, the government found out that they were going to get sued, and then CBP and USCIS issued the memo to say, look, this doesn't apply to existing H-1Bs. So as a result, the lawsuit did not get filed. The lawsuit is being revised. Apparently, there's 100 immigration attorneys that are working on this one lawsuit, which I didn't realize that it took that many people to draft a lawsuit. So I'm not a litigator, but I think the expectation is that lawsuit will be filed this week. The outcome's not guaranteed, because the courts have now said they don't like nationwide injunctions. So even if the lawsuit is successful, there's a question mark over whether it will apply to everyone or whether people will need to file individual lawsuits. But my feeling is the government's either going to back down or they're going to lose in court. And I think the big thing for me, if you look at all the posts and look at all the media attention, everything is focused on this $100,000 fee. But if you look at the proclamation, it also talks about a couple of other things. Are there any questions that you have on the actual fee itself before I kind of jump to the next topic?
Not the actual fee itself, Chris. Just to go back, I know there's so many moving parts. If our attendees today want to stay up to date on, when this lawsuit is filed, what the next steps are, does PSBP have a portal where they can maybe sign up, that y'all can send them email alerts, or other newsletters that y'all send out that our attendees today can sign up for?
It isn't necessarily, I mean, they can certainly sign up for, they can go onto our website and sign up for our newsletter. I post articles and videos regularly. I can certainly inform the chamber once a lawsuit is filed and kind of provide those details so that you can kind of share it with the members. But as of now, I don't know when the lawsuit will be filed. I don't think the people filing the lawsuit do, because again, they're still trying to figure out the circumstances in which this fee would apply, and based on those circumstances, they can then find the relevant plaintiffs. But I can certainly provide those updates.
Got it. Thank you.
Yep. So the reason I think the $100,000 fee is a big distraction is if you look at the proclamation, it talks about the Secretary of Labour, the Department of Labour, looking at prevailing wage levels. So when an employer files a H-1B, they have to pay a prevailing wage. And let's say that wage is $100,000. Well, if the department go through those prevailing wages and increase them, that means that $100,000 may now be $200,000, which means that every employer going forward, whether it's a new case or an extension or an amendment, will have to pay much higher wages, which means that the smaller to medium-sized firms are going to really struggle to continue hiring H-1B workers. The other thing that it mentions is, and this is a kind of directive towards the Department of Homeland Security, is to prioritize H-1Bs based on how much people are being paid, which means that the next H-1B lottery, instead of it being random selection, it could be based on the amount that people are getting paid. In other words, they will look at level 4, level 3 wages, which again, the big tech companies will benefit because they tend to pay the higher wages. The smaller companies are really going to struggle. So I think those two things are going to have a much larger impact rather than this $100,000 fee.
Got it. And you know, as we kind of get towards the end of this, Chris, are there other topics that you wanted to touch on? Because I did want to open up for Q&A shortly.
Yeah, just one last thing.
Yep.
Yeah, just one last thing. Yeah, and this is something that I saw this morning. So Department of Labour have announced, and it was dated September 19th. But again, I think because the focus has been on this $100,000 fee, it's probably not been well published. Department of Labour has announced something called Project Firewall. They're basically saying that they're going to start doing compliance checks. In other words, they're going to investigate H-1B employers to make sure that they're complying with the rules. They're potentially going to order back wages. They're going to impose penalties and potentially stop people from using the H-1B program. It's always been possible for them to do these kind of site visits and investigations, but this suggests that they may be upping those investigations, which means, again, for employers, you know, we can't complain about that, you know, the $100,000 H-1B fee and then, you know, not doing what we're supposed to do under the regulations. So if you employ H-1B workers, you have to make sure that you're paying them the proper wage. In other words, you can't bench people. You know, if somebody works at an end client and that end client project comes to an end, you have to continue paying them. You have to maintain like public access files. Because if you don't, and they do investigations, employers could find themselves in a position where they're not only having to pay back wages and penalties, but they maybe stop using the H-1B program. Not necessarily indefinitely, but certainly for a specific period of time.
Great. Thank you so much, Chris. That's certainly good information, especially, and you said it was called Project Firewall?
Correct. Yeah. And
okay.
I can share the link if that's helpful.
Yeah, if you don't mind, I'm sure if you don't mind dropping in the chat, I'm sure some of these attendees on here today would benefit from checking that link out. Thank you again, Chris.
It says that the chat is turned off for the meeting, so I can't share it.
We'll share it. If you want to send that over to myself or Melissa, we'll share it with our attendees here after the webinar. And I think Melissa will open up the chat here shortly. But thank you again, Chris, for your time, your expertise. I know this was all done in such a short notice, but we wanted to make sure that our chamber members and our attendees today had some clarity, you know, expert kind of information that you can provide them. But before we open it up to the Q&A, just wanted to do a quick overview again, as what Chris said. Things are still very fluid. A lot of folks from the immigration side are still educating themselves on the information that's coming down, not only from the administration, but obviously from CBP and USCIS. They're trying to understand the scope. As Chris mentioned, a lawsuit is imminent, will be filed pretty soon, so that will also change the landscape. We don't know as far as the fee where that will be paid, how that's going to be paid, so that's still kind of murky. But what we do know and what we can share with our members and attendees today is that from a chamber standpoint, partnering with PSBP Law, we want to provide y'all the most accurate and updated information that's coming down the pike. We want to let you know that we're here to support you with resources, with advocacy positions. So please, Melissa will send, I don't know if she has already, but she'll drop in the chat information where you can reach out to the chamber. We will share, Chris, if you don't mind, if you can share the information that we can share with our attendees, so we can blast it out to them if they have any questions. We'll share that with y'all. But we just wanted to put this together. I know it's a short amount of time, but making sure the attendees here and our chamber members have some type of clarity and we can answer their questions as to what's going on. So with that, Melissa, if you don't mind opening up the chat, we'll go to Alok. I know you've got your hand up, and we'll take about we'll be here for maybe, Chris, I know you've got a tight schedule today, maybe for about 5 to 10 minutes to answer some Q&A. Is that okay with you, Chris?
Yeah, absolutely.
Okay, great. Alok, I know you've got your hand up. We will go over to you. Melissa, if you can unmute Alok Gupta for his question.
Hi, can you hear me?
Yes.
Oh, great.
Sure.
Thank you. Thanks for taking the question and thanks for the great info session at the moment. I know things are murky. I have a quick question for the borderline scenarios, people who got approved for 2025 and they have yet to go for stamping. How does it impact them? Will they be undergoing scrutiny over there or 100,000 at that time because it's already approved for 2025?
So it shouldn't be. So if they're going for stamping, we're looking at what the Department of State is saying. So the Department of State says the restrictions on visa issuance and entry only apply to H-1Bs that were filed after the effective date, in other words, September 21st. So if somebody has been approved, let's say example for a cap case, they should be able to go for stamping and that $100,000 fee should not apply. The problem is, I think the Department of State and the consulates are still confused as to which circumstances it will apply to. So there may be instances where an officer says, well, look, this case, is applicable and the $100,000 fee applies, even though it doesn't. So my view, and I think the prevailing view, is that it should not apply. Based on the memos and based on the guidance, it doesn't apply, but that doesn't mean in practice, an officer that's not perhaps educated may say, well, look, it does apply. Okay. So kind of murky.
Thank you, Chris.
Thank you.
Thank you, Alok. Next we have Aishwarya T. That's the next person in our queue.
Yeah, hi. Can you hear me?
It's your volume is very low.
Can you hear me now, or is
there
it
you
better?
go?
Yeah,
there you
that's
go.
better.
Thank you so much for actually having the seminar. Super helpful. Just have one question. So currently I'm on F1 visa, and my employer will be applying for my H-1B next year. So I just want to know if the rule applies to the new applicants next year, because it's a little confusing as to, they say it's only applicable to people outside of the United States. And if we've studied here and we've finished our master's and now we are working, so does it apply for us next year as well?
Yeah, so we don't know. So the H-1B frequently asked question, and the Department of State has released similar frequently asked questions, and they both say that it will apply to the 2026 lottery. But the proclamation is really aimed at people outside of the US. So it's not clear will it only apply to people that go through the lottery that are outside the US, or will it apply to everyone? It shouldn't apply to everyone, but that's the kind of clarity that we need. So it shouldn't do, but I don't want to tell you that it won't, because USCIS is saying that it will apply to the lottery. But I think by the time the lottery comes around, we'll obviously know more by then. The lottery will, as I said, with the prevailing wages and the way that the selection will work, I think that lottery is probably going to look a lot different next year.
Thank you, Chris.
Thanks, Ashbury. Nikilan, you're our next, sir.
Hey, Kamal. Hey, Chris. Thank you for the
Hi.
session. I just had a follow-up question to like Aishwarya's question. So will this fee be impacted towards any O1 visa? So is there any news about this?
There's
Or-
nothing, and it doesn't seem, for some reason, this administration is fixated on the H-1B program. So this is specific to H-1B. We file O1s and they have not been impacted. I wouldn't expect this fee to apply because, again, O1 is extraordinary ability. And hopefully the government still want people that have extraordinary ability to be able to come into the US. But for now, it just applies to the H-1B. But that's not to say that the president doesn't sign another proclamation to extend it to other visa types in the future.
Okay. Thank you, Chris.
You're welcome.
Thank you, Nikilan. Shyamji Verma, you're
Hey,
next
hi.
in the queue.
Yeah. Hi, Kamal. Hi, Chris. Thank you for
Hi.
hosting. I have one question. My H-1B extension was filed in July, but the case is still pending. And 2 weeks ago, I changed it into premium processing, and the decision is still pending. And this was done prior to the proclamation news. And I have an upcoming travel in 2 weeks. Will this impact me?
So it shouldn't do because the petition was filed before September 21st. And again, the Department of State and all the guidance seems to suggest it only applies to cases that were filed after. Is this travel that you would consider to be urgent, where you absolutely have to travel?
Oh yeah, I have to tell it's really urgent, and I pre-planned it earlier, but if something goes on and off, I may not travel, but yeah.
Yep. So because the petition was previously filed prior to the cutoff date, you should not be subject to that fee. But again, because it hasn't been implemented, the government sometimes says one thing and does another. So if they implement it in a way where it does apply, then you could find yourself subject to the fee. But as things stand today, you should not be subject to that fee.
Oh, okay. Thank you, Chris. Thanks, Kamal.
You're welcome.
Thank you, Mr. Shyamji. And then we'll get to Claudette next. But before Claudette, we get to you, I did want to jump in really quickly, Chris, and ask, as Shyamji mentioned, if folks are traveling and let's say something happens at the airport and they get into a bit of, some Q&A with the officials there, does PSBP law have some resources where our attendees can tap into if something happens the day of and their travel plans get delayed?
Yeah, it's tough because when somebody is dealing with CBP, unless they have like a signed G28 for a specific attorney, I'm not going to be able to get involved in a case where, let's say, one of your members is traveling. The advice to somebody that comes into, questioning with CBP is obviously tell the truth, because the minute you answer something that's not truthful, they can use that as fraud or misrepresentation to turn people away. If somebody at CBP is saying, look, you're subject to the fee, and that person doesn't think that they are, if CBP doesn't allow them to come in, then ultimately that person is going to have to leave, and then it's probably going to be a federal lawsuit, and that may be the only way to deal with it. So yeah, it's not that we have a specific resource, and I don't think most attorneys can really offer that service. People can travel with signed G28s, but again, a CBP officer may not even call the attorney and allow them to speak to that attorney.
Got it. Thank you, Chris. Claudette, you are next in the queue.
Hi, thank you again, Chris, for putting this together. I had a question because we are potentially doing a rehire in October, and they already have an H-1B visa, so it would be a transfer. So would this impact that process? Would we just pay like the normal transfer fees.
And they're currently in the US, correct?
Correct.
So you should just pay the normal transfer fee. So we filed a H-1B transfer yesterday. It didn't ask for an additional fee. But again, the new fee has not been properly implemented.
Okay.
Now, there are some attorneys that are saying, if you change employer because it's not a straightforward H-1B renewal, which is what USCIS says when the fee will not apply, there's a possibility they could apply it to a H-1B transfer. But my personal opinion is it should not apply.
Thank you.
You're welcome.
Great. Thanks, Claudette. Karthik, you're next in line.
Hey, thanks, Kamal and Chris. I have a similar questions like a Cloudy. We are rehiring a consultant, but it's a change of status from BT to H-1B. The petition just received by USCIS yesterday. Do you think it's going to be subject to 100K?
It shouldn't be. Again, because the person is in the US, they're switching to H-1B. It should not apply. But again, based on the language of the USCIS that they put out, we only know that it doesn't apply to a H-1B renewal, which really means somebody that's with the same employer applying for an extension. So there's a possibility they could issue an RFE asking for that fee. I think it's unlikely. But again, we won't know for sure until we get that clarity.
Thanks, Chris.
Thank you, Karthik. Hussein, you're next in the queue.
Hey, Kamal and Chris, thank you for this. So again, a similar kind of question, this regarding the change of employer. So my current petition is valid, but the visa is expired. And if I go for change of employer, I understand the 100K won't be applied. But let's say after moving to the new employer, I decide to travel abroad and to India and then go for stamping. So will at that point, the consulate or CBP consider the new employer petition as the new petition and then ask for 100,000 fee, or?
I mean, I think so, because the Department of State guidance doesn't even use the phrase new petition. It just says a H-1B petition filed after 9/21. And it applies to anyone that's seeking entry or seeking a visa. So because that petition is being filed after 9/21, and because you would be traveling and you would need to either go for a visa or come back to the US, I think they could apply the fee in that case. And that's kind of one of the gray areas, but I think that's one of those circumstances where it could be applicable.
So in a scenario where I let's say I travel right now and get the visa stamped, and then I come back and then change the employer, and then if I have to travel again and come back on the same visa and don't go for stamping, then also it's still a risky thing to do, right? Because you may be stopped at the port of entry or something.
Correct.
Okay.
Great. So we've got two more folks. Chris, we'll take two more questions. I know, folks, I mentioned y'all probably have more questions after this webinar. We will send you information on how to contact the chamber, how to contact PSBP Law. Want to make sure y'all have those resources, because we want to make sure we, from a chamber standpoint, can be a resource for our members as they guide these uncertain times. Next in queue is Het Butt.
Hello, Chris.
Hi, Het.
I have a quick question on all the pending H-1Bs that were filed for 2024. We have several companies within, which is owned by one person, and there's 2 to 4 H-1Bs that are currently pending. What do we need? Like, what should we expect? We haven't, I mean, they are just pending. Obviously, we haven't heard anything back. What do we expect?
Yeah, I mean, if they're pending, and obviously these cases were filed before 9/21, they should just be processed in a normal manner. That you shouldn't be receiving an RFE or any kind of request from immigration asking for that $100,000 fee. So for cases that are already pending, that fee does not apply, at least based on the current guidance.
Yes, but I mean, are they going to have any stricter processing than just deny the case, or I mean, what to expect?
Yeah, I mean, there's not been any change in the rules, but I think generally we're starting to see more RFEs, NOIDs, notice of intent to denies. We've seen a couple of denials, not necessarily on H-1Bs, but I think the level of scrutiny will only increase, and we're probably going to start seeing denials where there's no basis for, no legal basis at least for that denial. So I think we've got through the first 6 months of the administration where everything was perfectly fine and we were receiving approvals. I think the next 6 months and going forward, things are likely to change.
So do we expect processing times to be more longer?
I mean,
Like
I think
further
generally,
extended?
yeah. Yeah, I mean, I think under the current administration, it was the same under the last Trump administration, processing times will increase. For cases where you need to get people to the US or you need a faster decision, obviously there's the option of premium processing.
Understood. And are we expecting any changes in the EB-5 category? Any proclamation or any changes that can happen in the EB-5 category?
I mean, I don't think so. So my business partner handles EB-5, but obviously there's the introduction of this gold card, which kind of contradicts the EB-5. But I don't believe there's been any proclamations specifically targeting EB-5.
Great.
Okay.
Thank you, Chris. Thank you, Head. I do want to get to a few questions, Chris, that were put into the chat. So if you don't mind, I'll just read the first question for you. This is from a person that says, I'm currently on the process of getting a green card, and they've filed for the PERM LCA in August. When they get their I-140 and apply for the H-1B, will that also come under this fee, the 100K fee?
I mean, if they're in the US, oh, sorry, no, I am transferring out. So if the I-140, and I think I think I gave a similar scenario, but if they're outside the US, the I-140 gets approved, and now they have to apply for what you would consider a new H-1B, not subject to the CAB. That's a situation where I think the new $100,000 fee would apply.
Thanks, Chris.
Yeah.
And what I'll do is I'm going to get Sabalaji's question, Chris, if you want to answer that. And then our last question for today is with Hirul. So Hirul, we'll end with you as our last question.
Sorry, you wanted me to look at Balaji's.
If you want, yeah, I think Balaji had the last one for our chat, and then we can end with Hirul after you answer Balaji's question.
Yeah, so if those H-1Bs are already in process, they should not be subject to this fee. In terms of concerns regarding travel, again, I wouldn't, if these H-1Bs are ultimately approved for a change of status, obviously they'll switch from F1 to H-1B. If these cases get approved for consular processing, then they would have to leave. But again, I would advise against travel if at all possible.
And then Hirul, you're last in our queue for our Q&A portion.
Yeah, thank you, Kamal and Chris, for giving me time. So, Chris, I do have two questions. One, we do have an employee who visa expired on September 15th, but we applied for the renewal process in the month of June, and the case is received in the July. It is still in process, but the person is resident of Canada. So he works for us, traveling. So that is one scenario. What would be the case for that person? And the second
so
ahead,
let me just answer that one first so I can remember the details. So that person shouldn't be subject to this new fee. Canadians are visa exempt in any event, but I don't think this is a situation, because that petition was filed before 9/21, based on the guidance, that person should not be subject to that fee.
Okay, so you mean to say that he's not a Canadian citizen, they are the permanent resident. So that's the reason, currently he's outside of US, residing in Canada. So see that this 100,000 fee doesn't apply to him, right?
It shouldn't do, because again, it only applies to applications that were filed on after 9/21. So because it was filed before, that fee should not apply.
They have to go for stamping, right? That's where I was a little bit confused. even though you mentioned it several times. So that's why I want to make it clear.
Yeah. So if you and I can let me add. So I just added the project firewall to the chat. So the other thing I'm adding is the guidance from the Department of State, which basically says it only applies to those where the H-1B was filed after the proclamation effective date of 9/21. So even if somebody needs to go for stamping, as long as the petition was filed before 9/21, they should not be applying that $100,000 fee.
Okay, so yeah, thank you very much. And the second question is, we do have one more candidate who was got H1 picked up through some X company, and at the port of entry, he was denied because of lack of submitting the proper documentation. Now we are trying to hire him through our company. So that's like in a new petition, right? Or is it going to be change of employer, even though he has a approved H1 status, H1B?
But he's outside of the US.
No, he's not in the US. One time he entered in the US, and the second time he was denied for that X company. So that's where he approached us. So can we still go ahead with that change of employer status, or will it be a new H1B petition for us?
So the way I always file those cases is a new H-1B not subject to the cap. You can only do a H-1B transfer if somebody is in the US. So in this scenario, the person is outside the US, the H-1B petition would be filed after the effective date. So in that situation, they would be subject to that $100,000 fee.
Okay, cool. Yeah. Thank you very much, Chris. Thank you, Kamal, for the time.
Yes, sir. And
welcome.
Chris, thank you again. As we wrap up our session, I know our attendees today you guys will probably have additional questions as we move forward through this process and as we get more information. But I did want to say thank you so much to Chris and PSBP Law. As I mentioned earlier, this was put together in a very short amount of time. As Chris mentioned, Friday is when we got the proclamation directive. There were changes Saturday, more changes Sunday. So we were in consultation with PSBP Law and Chris was able to really pivot his schedule on a quick drop of a dime. So thank you again for doing this, Chris. I know there's a lot that you're kind of educating yourself on as we move forward with this process. So just wanted to again reiterate our great partnership that we have with PSBP Law. Again, many of our members probably know them through Patel Law Group name, but they have rebranded to PSBP Law. So they are one of our trusted immigration attorneys that we really use all the time. A lot of our members use them for their immigration needs and even EB-5 needs and whatever else is intertwined through the immigration process. So what we'll do after this, our attendees will receive an email with information on how to reach out to the chamber. We'll have Chris's information and information on PSBP Law. We do encourage you, if you have additional immigration needs or any legal needs, please reach out to Chris and the PSBP Law legal team. I cannot reiterate and say how much we've enjoyed working with them on so many issues, in addition to what immigration brings forth. You saw that we will also share this link for the recording, so you have this information moving forward. Again, thank you, Chris. Thank you, PSBP Law. Thank you to our attendees for hopping on this morning. We will be in touch. If you haven't signed up for the Chamber's newsletter, please go on our website, sign up for the newsletter. We will try to send you as much information as we can as we receive it from our partners. Chris, with that, anything else you'd like to end with?
I don't think so. I think just obviously keep an eye out for any updates. If there are any updates later this week or next week, I'll make sure that I post about that, whether it's on YouTube, on the PSBP Law website, and obviously making sure that I send that to the chamber so that you can kind of share that with members as well.
Awesome. Thank you so much, Chris. Again, from the chamber side, we are here to be a resource to our members and the entirety of the Indian American business community. We want to make sure on an advocacy front, we are there to support you, support our members. I'm going to drop the link for our website. If you haven't signed up for our newsletter, we're going to send out information as we get it to keep everybody updated. Thank you again, Chris. Thank you to our attendees. And please be lookout for an email with follow-up information on how to contact us and resources you can use to navigate these uncertain times. Thank you all again. Thank you, Chris. Have a good rest of the day.
Thank you. I appreciate it. Bye.
Bye.